Is referred to as la tómbola.
Was the death penalty imposed on Mr. Pujols?
The death penalty was, by the First Circuit determined that the death penalty is applicable in Puerto Rico. What we're saying is that we find that decision was erred.
I think his question is, did the jury in the Pujols case recommend the death penalty?
We don't have the details to that. I can tell you that Acosta Martinez, the death penalty was applied, and as a punishment to the federal government, the people in that jury decided to acquit both defendants.
Okay. Go ahead.
Yeah, Pujols, I think the procedural posture that is before us in Pujols, it was a motion made to the district court dismissing the action because of inapplicability of the law, and that decision of the district court dismissing the action has come to the to us.
Okay.
As we were talking about congressional intent, we see that in Congress's actions, when they revised Puerto Rico's constitution, they made determinations as to what could or could not be on that constitution, keeping in mind the federal regulations. The death penalty will not exist in Puerto Rico. The people of Puerto Rico are not willing to impose it.
I hear what you're saying about, now, had they said, all right, Puerto Rico, and your local laws, you have to impose the death sentence. They didn't say that, they left that intact, that you did not have to under your local law. But that does not necessarily transfer to federal laws, does it?
No, it doesn't, but
couldn't other people say, well, Puerto Rico can't die under this law, why should we die under this law?
Well, we're asking you today to determine it for Puerto Rico.
Your answer to Justice Perry would be as follows. We do not die because we do not vote to die. You, in the United States, you can die because you vote to die.
Not necessarily.
I
don't want anybody that's been sentenced to death voted to die.
The Congress, the Tea Party people.
Tea Party, yeah.
Can I have a minute?
Oh, that's fine. But that's
can I have a minute to finish my...
You go ahead.
We're asking that the federal death penalty not be applicable to Puerto Rico. One, because it goes against the Puerto Rican Constitution, which Congress allowed. Two, because it's a due process violation. We are not allowed to vote. And that is in essence part of what the Republican government of the United States was established.
But isn't the jury system the essence of government, of the people, by the people, and for the people? And the jury makes a determination. And you said that the jurors in Puerto Rico just simply nullified that. So why are we arguing this?
Because the juries in Puerto Rico in federal cases are different and are limited. Not every
you have different Puerto Ricans in federal cases?
Well, Puerto Ricans in Puerto Rico, not all speak English, which you're required to speak in order to be part of those juries. Usually those are people in higher class, they've been educated differently, and essentially
they don't mind dying.
They're not peers. They're not peers.
Okay. Thank you.
May I ask, how many of the three arguments are you doing personally?
I'm doing the first argument, Your Honor.
The first one?
Yes, that the statute is locally applicable to Puerto Rico.
Okay, very well, thank you.
Oh, you may proceed.
May I proceed? Thank you. Good afternoon, Your Honors, Chief Justice, may it please the Court. My name is Jacqueline Guzman, and I, along with my co-counsel Rebecca Medina, represent respondent in this. Your Honor, is not from the perspective of, it's not the local perspective of Puerto Rico. It's the congressional intent for the statute to apply. And here, that congressional intent for the statute to apply can be seen.
So contrary to what your counterpart said, Puerto Rico cannot veto federal law.
Your Honor, no. This court and no lower court has ever found Puerto Rico to be able to unilaterally accept federal laws from Puerto Rico merely because of a constitutional conflict.
Is the reverse true?
Your Honor, the presumption in Justin Mercado versus the Commonwealth does create a presumption that federal laws do apply to Puerto Rico unless Congress explicitly states otherwise. Now, the case, for example, Your Honor, in United States versus Quiñones, that involved a blatant conflict of a federal statute with the Puerto Rico's constitutional ban on wiretapping. In that particular case, it was found to apply regardless of Puerto Rico's constitutional ban.
Well, not only that, but what I've been garnering here is that there have been some statutes created by Congress that explicitly state that it applies to Puerto Rico. Some statutes that do not say whether it applies explicitly or not to Puerto Rico, yet it has been found to apply to Puerto Rico. And then there has been some statutes that do not say whether it explicitly applies or not explicitly apply, but have been found not to apply to Puerto Rico. So it's going every which way.
Yes, Your Honor, there is some confusion.
So how are we to clear that confusion now when we issue this monumental decision?
Well, Your Honor, if we look to the Justice of the Commonwealth of Puerto Rico in 2007 actually testified regarding Puerto Rico's applicability of the Death Penalty Act. Now, in that particular Senate hearing, that representative made clear that Puerto Rico had a unwavering and broadly accepted rejection of the death penalty. Yet, since 2007, Congress has not added an explicit exemption for Puerto Rico. In fact, Congress, and did so through the text, through the statutory scheme, and also since 2007.
You mean apply to Puerto Rico, you mean?
Yes, Your Honor, spoke. Applying to Puerto Rico. Congress has known since 2007, even arguendo if we accept petitioner's contention, that Congress did not anticipate or think about necessarily how this would affect Puerto Rico. We can say that since 2007, Congress has known that Puerto Rico has an entrenched constitutional abhorrence to the death penalty, yet they still have not exempted Puerto Rico. And that, Your Honor, is very telling considering the special relationship that Puerto Rico has to the United States. Now, the United States and Puerto Rico both entered into the U.S.-Puerto Rican Compact. And
so are you saying then that even if it were to be established that Congress intended for the FTPA to apply to Puerto Rico, that there is no challenging Congress's power to do so?
No, Your Honor, there is no challenge to do so, as the United States maintains plenary powers over Puerto Rico, and the people of Puerto Rico agreed in the U.S.-Puerto Rican Compact, which included the Federal Puerto Rican Relations Act, to have all federal statutes apply.
So what weight do we give to the language about the local inapplicable, not locally inapplicable?
Your Honor, the First Circuit got it right in that case, and the First Circuit said that refers to congressional intent for it to apply to Puerto Rico. But we don't even have to go to that second prong, Your Honor.
Because you're saying that the intent is clear, because the intent is clear, we don't have to go to the second prong. So what I'm saying, assuming that's correct, you're saying that then means we do not need to go into that phrase, locally inapplicable.
No, Your Honor, we do not need to go into a locally inapplicable.
So Congress is the one who's determining whether it's locally inapplicable, not Puerto Rico.
I'm sorry, Your Honor.
So Congress is determining whether it's locally inapplicable, not Puerto Rico.
Correct, Your Honor. And that is the agreement that was signed that was agreed to by both parties through the U.S.-Puerto Rican
Because I think you would agree with me that key to resolution of this issue is to determine who is responsible for making the locally inapplicable determination.
Yes, Your Honor.
Okay, I believe your time is up.
Oh, okay. Thank you very much.
Thank you.
Yep. Good.
Constitutional principles. Your Honors, upon acquiring Puerto Rico as a territory and further as they became a commonwealth, we have always maintained a plenary constitutional authority over Puerto Rico. Now, Your Honors, in passing the Federal Death Penalty Act, Congress was merely acting within their power to apply this to Puerto Rico.
Your Honors, Puerto Rico does not gain a special exemption merely because their constitution states otherwise. Here, since we have that broad plenary authority over Puerto Rico, it is fair that Congress does apply this to them. Now, Your Honors, the contention that just because we are dealing with death means that they should receive a voting representative in Congress is false. Now, in this instance, the content of the policy in which we are applying does not equate to a violation of substantive due process. They do have a representative in Congress who speaks on their behalf, and their voice is noted in Congress as well. Furthermore,
does he have a vote? In other words, if there's a tie, can he put in the tiebreaker?
No, Your Honor, he
If he's
cannot.
the vice president, he did.
When he becomes vice president, can he do it?
Your Honors, in this instance, we look to the Constitution to see who gains the representative vote in Congress. Now, the Constitution clearly lays out that the states will gain a voting representative in Congress. However, the key factor is that Puerto Rico is not a state.
Really?
Yes, Your Honor. Puerto Rico is a commonwealth. And
All
in
this time I thought Puerto Rico was a state.
Your Honor, as a commonwealth, they do not gain the representative vote under the Constitution. Now, this court has held in the past that there is a hesitation in expanding the definition of substantive due process in order to expand it. Now, Your Honors, here, rather than expanding the thought of the concept of substantive due process, we should maintain the constitutional principles that we do follow. In this instance, the theory that not having a constitutional representative in Congress, a voting representative in Congress, does not shock the conscience. First, this court has never held that a legislation shocks the conscience. This court has only applied fundamental constitutional principles that we are asking you to uphold. Just because it is the death penalty does not give Puerto Rico a right to have a representative vote in Congress. There are certain, in addition, there is a jury who would decide at the end whether or not the citizen will be subject to the death penalty, Now, with this death penalty, they are receiving substantive due process since they gain the jury to determine whether or not it does apply. For these reasons, we ask this court to uphold the decision and find that the Federal Death Penalty Act does apply to Puerto Rico. Thank you.
Thank you. Rebuttal? How long? 3 minutes? You may proceed.
Council Freddy Hernandez for Interamerican University. Your Honors, the sister council referred to the exclusion of the Indians, Americans of the Federal Death Penalty Act, and we'd like to state that Indians have they vote in the United States. Puerto Rican, we don't have that right yet. So there's a right explain difference right there about the difference of both cultures. We also would like to express quickly to the argument of U.S. versus Quiñones, the Wiretap Act. We think we think that the Wiretap Act was applied as an evidentiary issue. On the discussion before the enactment of Puerto Rican Constitution, Congress in Puerto Rico thought that this could happen. They thought that eventually the wiretapping could be applied, but on this case, however, we're talking about the right of living. We're talking about death penalty. It's not the same thing that's happening in this case. Also, the ICCPR Council also established that it was not self-executing. We do understand that it was not, but under that pact, Congress also was obliged to legislate in order to enact the different process for this to happen, we would like to not to only argue the rule of law, but help to change it and developing into the reality of Puerto Rico. Thank you.
Thank you. That's it, right?
All right.